Hi, everyone, and thank you for joining us today. My name is Andrea Akins, and I'm the Digital Marketing Specialist here at Frank Crum. Today's topic is an employer's guide to the Family Medical Leave Act, FMLA. Now, I know many of our Frank Crum clients are on this call today, and I'd like to take this opportunity to say thank you for your business. We really do appreciate it. And for those who are not our active clients, welcome. I'd like to start with a brief overview of our business, and then I will introduce our speaker for today. At Frank Crum, our family of companies consists of Frank Crum PEO, Frank Crum Staffing, and Frank Winston Crum Insurance, and we are located in beautiful Clearwater, Florida. We are family owned, and we have been in business for over 35 years. Frank Crum is a professional employer organization, or a PEO, and that it enables clients to cost effectively outsource the management of human resources, employee benefits, payroll and payroll taxes, and workers' compensation. As a result, our clients can focus what they do best to maintain and grow their bottom line. Now, let's get started. Presenting today's webinar is Frank Crum's HR consultant, Nanette Madera. Nanette is a bilingual, certified professional human resources professional, and she has over 15 years of experience in human resources, management, training, and organizational development. She is also a consultant for Frank Advice, our premium HR consulting service that we provide to our clients. With Frank Advice, you could get instant access to experts like Nanette to answer all your HR-related questions. Now, presenting Nanette.
Thanks, Andrea. And hello, everyone. I want to welcome you to the webinar today, An Employer's Guide to the Family Medical Leave Act. Now, let me just start off by saying that I know I'm going to be throwing a ton of information your way today, but there's some key points that I want you to take away. And those are exactly what the Family Medical Leave Act is. Are you legally required to offer it? What the company's responsibilities are in this process, and then what the criteria are for the employee and employer to meet in order to be able to qualify for this benefit. And so we're also going to be talking about a little bit about the forms and what the posting requirements are. So the first thing is we're going to make a differentiate what state versus federal is. And so as we talk about the Family Medical Leave Act, I'm going to be talking about what the rules are on the federal level. Depending on where your business is located, in what state, there may be other laws or rules or even benefits or different eligibility requirements that come into play. So depending on what your state is, again, it may be something that may differentiate from what we're talking about because we are only focusing on the federal level. Just quickly, some of the states that do have different rules are California, of course, Connecticut, Hawaii, Maine, New Jersey, Rhode Island, Vermont, Washington, and the District of Columbia. So there may be others, but again, it really depends just on where you're located. And so, as always, we are here, our Frank Advice team, to assist you through the FMLA roadmap. So for things such as, those state-specific roles that we were just talking about, you can contact us directly for guidance. And if you do not already know how to contact us, don't worry, we're going to provide you with that information before the webinar is over. So first off, let's talk about what is the Family Medical Leave Act. The Family Medical Leave is more commonly referred to as FMLA. I've heard some people call it FMLA. And it's a law that was passed in 1993, and it entitles certain employees of covered employers up to 12 weeks of unpaid job protected leave each year with continuation of health insurance coverage. So the keywords here are certain employees and covered employers. employees need to meet certain criteria to be eligible to take FMLA, and covered employers also have a criteria to meet before they have to offer it. So we're going to cover that a little more in detail. But for now, let me just tell you that the purpose of the Family Medical Leave Act was to provide employees with additional benefit of the opportunity to balance their work life and their family life if they're ever faced with their own illness or the illness of a family member. And so the idea was that this benefit, it would promote economic security of family and serve as a national interest in preserving family integrity. Now, the Department of Labor, who was the driving force behind this act, has stated that the best available evidence suggests that adopting flexible practices in the workplace potentially boosts productivity, improve morale, and benefits the economy. Now, what does this mean to you as an employer? Well, do you have to offer it? That's usually the first question that comes to mind. So the answer is maybe, if and only if you're considered to be an FMLA covered employer, then you're required to offer the benefit. And so for a company to be considered a covered employer, the company will have to have 50 or more employees within a 75-mile radius for at least 20 work weeks in the current or preceding calendar year. Now, some tips on calculating your employee totals for determining if you are an FMLA covered employer. Well, first, you need to count all of your employees. Both full-time and part-time employees are counted. This is a little bit different from the count that is required by the ACA, where you do full-time equivalents. Here, you're just counting all the employees. And then second, if you're a joint employer with another company or a successor to a covered employer. So what does it mean to be a joint employer? There are those who have ownership in more than one company. Now, the thing that we come across the most common is, let's say that Jane is the sole owner of Fantastic Inc., and she only has, let's say, 20 employees there. If Jane also is partial owner to CBA company, let's say that company has 30 employees. Well, if these two companies are located within a 75-mile radius of each other, then both companies would be considered covered employers. And then it doesn't matter if the companies are in different industries or if they have different federal ID numbers. Regardless if they're different entities, the ownership may qualify you as being a covered employer. Now, let's say there's a third company that, let's say, is 200 miles away. They would be considered an FMLA covered employer only if they by themselves have 50 or more employees. So the same thing applies for successors. So if you are someone who's purchasing, taking over, or maybe inheriting a company, then if the company is an FMLA covered company, you still need to offer that benefit to your employees. So now that we've established that your company is considered a covered employer, what are your responsibilities? Well, the first step is to determine if an employee is eligible, because remember, they also have to meet certain criteria in order to be able to get the benefit. And so you need to understand, if they're eligible and that what that entails. And so um, we're going to kind of look at if they need to take the FMLA. In the coming slides, we're going to talk about their eligibility requirements and how much time they're eligible for. Um, the second step is to go through the NORDIS certification process. And so you want to do this because there are certain things that happen within that process. And one of them is informing them of their rights, which you have a responsibility to do. And then you want to be able to establish um, that they've been notified of those rights, whether they need the medical leave or if you have the knowledge that the absences they're taking may be for an FMLA qualifying event. So, one and very important factor to understand is that, and this has been supported by the courts, an employee doesn't need to come to you and say, I need to take FMLA. They don't have to ask for it by name, whether it's FMLA, FMLA, or Family Medical Leave. As their employer, you need to offer this benefit to them if you think that they're likely to qualify for it. And so we're going to talk about how to kind of determine when there may be a qualifying reason. So to initially determine if the reason for taking leave qualifies under FMLA, you will request medical certification if necessary. You will follow up with the employee. For example, as many times employees do, they don't return the paperwork when they're supposed to. And so this is also the process where you designate the leave as FMLA or deny it if they don't qualify for it. And so you want to make sure that you designate it. The FMLA is one of those things where you're not likely to be able to go back and designate the time. So that would mean the employee would qualify for even more time from the time that you designate it, since you can't do it retroactively. And then if an employee is not eligible, and again, you want to make sure that you document that. And anytime you're denying FMLA leave, be sure that you provide a reason. And so that's why the documentation or the certification process is really important, because you want to be able to say, I wasn't discriminating against the employer or retaliating for them asking for FMLA leave. The employee simply did not meet the criteria, or hadn't worked here long enough, or whatever the case may be. And then the third thing is to reinstate the employee at the conclusion of the leave. At the end of the employee's leave, so they've used up their time, you have to reinstate them to either the same position or something that's substantially equivalent. So what does this really mean? It means that you reinstate them to something that's the same or virtually identical in terms of pay, benefits, and any other employment terms and conditions. And this isn't uncommon, that there are times where an employer will hire someone on a temporary basis to kind of fill in for that employee that's out on FMLA. And then there may be nothing wrong, except that maybe you're just like the person that's the temp a little more. Maybe they're a little more efficient, or they don't have the attitude that the other employee leaves, and so they're just easier to work with, or we can insert here many reasons. But the problem comes in because when employees entitled to take FMLA and they take it, you can't retaliate against them for taking it. And so by you not reinstating them, you can potentially leave the impression that that's what you're doing by not reinstating them. And so this is usually where we see lawsuits that employers have to defend themselves against. And then they have to provide the reasoning for their termination. And so unless it's something egregious, such as, while this person was out on FMLA, let's say it's somebody who works with your books and you come to determine that they've been embezzling for the company. Well, make sure you document everything properly. And in this case, you will be able to kind of justify your termination, not having to do anything with the fact that they requested the FMLA. It just so happens that they were on FMLA when you discovered the embezzlement. And so, um, hoping that's kind of making sense. So, now let's talk about the employee and who is eligible for the leave under the Act and what's the criteria that they have to meet. They have to have worked for the company that has 50 or more employees within that 75-mile radius. And they have to have been employed for you for at least 12 months. And the time doesn't have to be consecutive. So if they worked for you for a certain amount of time and they had a small break and then came back, well, so long as they've worked with you for 12 months, and they have to have worked at least 1,250 hours in those previous 12 months to be eligible to request a FMLA. One important thing for an employer to know is that an employee, again, they don't need to come to you and ask for FMLA by name specifically. As the employer, if you know an employee is requesting time off and it's for reasons covered under the Family Medical Leave Act, then it's your responsibility to offer the leave benefit. There have been unsuccessful court cases where the employer's defense for terminating an employee was that they didn't request FMLA. So it could be that someone is having some attendance issues and they're not coming to work. It could be because of an illness, and then you just, discipline them for attendance and, don't really communicate to them that they have the option of requesting FMLA. So be sure to communicate with your employees and offer FMLA if it appears that they're going through a qualifying reason and may be eligible for it. That's very important. So, how do you even know if it's a qualifying reason and when to offer it? Well, according to the Act, the instances that are listed are for incapacity due to pregnancy, prenatal medical care, or childbirth, to care for an employee's child after birth. This includes the dads too. Or if there's an adoption or a foster care placement, to care for a spouse, son, daughter, or parent who has a serious health condition, and to care for an employee's own serious health condition that renders the employee incapable of performing the functions of their position. So earlier, when I mentioned that if it appears an employee is going through a qualifying reason that you should offer the FMLA, well, here are some things that can kind of prompt you to offering it or discussing it with the employee. So if you have an idea that, they have inpatient care, which is anytime there's some type of hospitalization, anytime there's some incapacity plus treatment, so anytime that there's a temporary disability and there's a need for medical treatment, any chronic conditions, or any conditions that are either permanent or long term, and conditions that require either continuous care or separate medical treatments. Now, it's common for employees to disclose this information when there's an attendance issue and they're being counseled about it. So this is a very important reason why, as a business owner, that what you want to make sure that your managers and supervisors have some training on the Family Medical Leave Act so that they too are equipped and can recognize the red flags of when FMLA may come into place. Otherwise, they may never bring it to your attention or the attention of an HR person, And they may continue a corrective action process um, instead of offering, FMLA. They may still be writing somebody up and eventually lead to termination of an employee based on attendance rather than being offered FMLA. Other qualifying reasons are directly related to military or service members and their families. In this instance, for a qualifying reason, it's a little different. Employee may be eligible to take up to 26 weeks in a 12-week period. So, they get a little more time. And so the qualifying reasons would be to care for a spouse, son, daughter, parent, or next of kin who's a service member and undergoing medical treatment or is either recuperating or in some type of therapy, whether it's inpatient or outpatient. Um, or if they have a temporary disability that they're listed on that military child list. Um, to care for a veteran undergoing treatment. Now, this again, it includes medical treatment. It includes, the recuperation, therapy, whatever it is that they need to get better. And the injury must have been incurred in the line of duty or existed before the beginning of the member's active duty, and it could have been aggravated by the service. So, again, the medical certification will kind of clear all this stuff up for you to determine. And then qualifying exigency arising out of the fact that employee's spouse, parent, or child is on a covered active duty or has been notified of an impending call or order to covered active duty. Or to care for a military member's parent who is incapable of self-care when the care is necessitated by the member's covered active duty. So let me point out two things here. One is that I have already mentioned that for the military leave, the leave can be for longer than the 12 weeks allotted for, the medical leave. In some cases, an employee may be entitled to a combined total of 26 work weeks of leave for any FMLA qualifying reason during that 12-month period. And so up to 12 months of the 26 weeks, it could be that an employee had to take for FMLA qualifying reason other than to care for a covered service member. And so if they've already exhausted their 12 weeks of FMLA and then they have a qualifying reason for military, then they may be entitled to the remainder of the weeks. So it would be 14 weeks additional of FMLA care to cover, to care for a service member. And then the second is that you do not need to know all of these things off the top of your head. All this information is listed in the FMLA posters. And again, our Frank Advice team is here to help and guide you. So we have been talking about the qualifying reasons, and these mention immediate family members. And so, it kind of defines some of these family members. However, let me share with you, there have been some interesting developments with, and again, some court cases where the eligibility of leave has been denied by employers based on their own interpretation of what a family member is. And so, for example, here, let's take a close look at how spouse is defined. It's defined as a husband or wife, or as recognized in the state where the individual was married. This includes common law marriage or same-sex marriage. Spouse also includes a husband or wife in a marriage that was validly entered into outside of the US, if the marriage could have been entered into at least in one state. And so you want to be sure that you're not interpreting whether or not the person is a spouse. If someone provides you the documentation or gives you all the documentation, that you're not denying FMLA based on a technicality of what you think a definition is. So, parent. And this is another one that people sometimes get hung up on. So, parent is defined as a biological, adopted, or foster father or mother, or any individual who stood in loco parentis to the employee when the employee was a child. So, what does this mean? If you have an employee who was raised by their grandparents, then their grandparents kind of stood in loco parentis for the employee, and he or she would be eligible to take FMLA to assist with their care. And so, of course, you're not going to know, that your employee, when they were a child, was raised by their grandparents. But this is something, again, communication is key. You want to be sure to talk to your employee, get the information that you need, and that you're not quick to just deny FMLA leave because you're saying, well, they were not your parents and they didn't adopt you, and so you're denied. No, you want to be sure that they don't meet the loco parentis status. Son or daughter is defined as a biological, adopted, or foster child, a stepchild or legal ward, or a child of a person standing in loco parentis who is under 18 or who is over 18 but is incapable of self-care because of a mental or physical disability at the time that the FMLA leave starts. So the onset of a disability may occur at any age for purposes of the definition of an adult son or daughter. For example, if you have an employee who is requesting FMLA leave for, let's say, their minor nephew, again, don't be quick to say, no, you're denied, because what you should be looking at is, the fact that while this child may not be biological son or daughter, um, it could be that the employee is standing in that loco parentis. So if this person is raising this niece or nephew, then they may be entitled to it. So um, again, don't be quick to make judgments, and you want to make sure that you communicate with the employee and don't make these interpretations yourself. So there's a few notification requirements that every employer has to do. And so the first thing is that you should be having the poster posted somewhere, and it has to be somewhere where the employees will see it or in a conspicuous area. And the purpose of these requirements is to kind of establish effective communication. And this is really the key component to manage FMLA. So you need to provide employees with a general notice. Most of you are familiar with those, humongous posters that HR usually places everywhere. You know that you have to post it in a place where the employees can see it and have easy access to. The poster, the most up-to-date poster, you guys have quick access through it through the myfrankcrum.com portal. You can click on the resources tab. But don't worry, we're going to be sending out the recorded webinar, and along with that webinar, we're going to be including the posters and the forms that I'm going to be talking about in the upcoming slides. So don't feel like you have to run now and get the posters. Anyway, the posters, they're supposed to give the employees, notify them of their right to take FMLA and what the eligibility requirements are and the major provisions. Some tidbits on the posters is that electronic posting and distribution are permitted as long as the employees have access to it. So if you're a company that has remote employees, this is a really common question that we get all the time, and so they don't have a place where they go to, you can email them the poster. And then for those companies who have a majority of their human resources or their employees, they don't speak language. They don't speak language. They don't speak English. That's not their main language. Then you want to make sure that you post the poster in whatever the most significant language is, and you can always have it in more than one language. So again, we already know that employers need to notify employees of their eligibility status and rights and responsibilities under the FMLA, or Family Medical Leave Act. And so there's a form, which is the WH 381. It's a form, general form. Again, we're going to send you these forms. This form is not required. However, this form, when it's fully completed, it provides the employees with the required information that's required under the Act. And it's also the form that you can use to let the employee know whether the FMLA was approved or denied. Of course, the reason why, as I had mentioned earlier. And then it allows you to establish the terms of the FMLA leave. So you can say, yes, Jane Doe, you're approved for FMLA. You're going to start on this date. You're required to come back by, 12 weeks on this day. And I am requiring you to bring me a fitness for duty form upon your return. So this is where you establish those things. So Form WH 382. This is the designation notice. And again, you will designate, again, this is kind of like a second step or a follow-up to the previous form, the 380. And you reiterate some of the terms established in the notice of eligibility, which is the 380. And this is where you can tell your employees, listen, Jane, you're eligible for FMLA. It will start on this day. You will need to use your PTO at the same time that you're out, or all your vacation time. And we require that fitness for duty prior to returning to work. And, it kind of establishes everything in writing so there aren't any misunderstandings. Now, one of the things that kind of throws a glitch in the process sometimes for employees is, what happens if the employee that needs to take FMLA leave, their leave was unexpected? It could be that, they went home for the day and then they never came back because something happened, and so they ended up, in inpatient care. So what do you do? Well, you still have the responsibility to do the notification. So you want to make sure that you still complete the designation form, and you can send it to the employee by mail. So that way they know that upon the return, this is what you ask of them. They know that this time is going to be considered FMLA. And so, you can establish all the specifics that we've been talking about that are covered on the forms. So I mentioned the fitness for duty form. And this, again, it's not mandatory, but let's talk about why the fitness for duty form plays an important part in this process. So what the fitness for duty form is, it's a form that the employee will take to their medical provider once they're about to return to work. And this fitness for duty form tells you, um, yes, John Doe is cleared to return to work, back to full duty on this date. Or it could say, well, John Doe is cleared to return back to work, and there's a restriction. John Doe can't sit for more than 6 hours in a row. And so it'll let you know that every 2 hours, John has to stand up, walk for 2 minutes, and then go back to sitting, or something along those lines. And so it, it'll give you the opportunity back in that designation form to ask for it, like I mentioned earlier, but it will ensure that your employees are ready and, in fact, can return to work to complete their duties without compromising quality or safety of the position. Now, that being said, it would benefit you as their employer to send them the form. And so the best practice is to include the employee's job description. And the job description usually has the essential functions of the job. But if you do not have a formal job description, you can send a summary of the position with the essential functions of the job. And so when the employee takes the fitness for duty, the job description or the summary should be attached. And then this will give the medical provider assistance in determining exactly if the employee is fit to the job. Otherwise, the medical provider is really relying on what the employee is telling them, what their accurate duties are, for them to determine if the employee can safely carry out those duties. So the fitness for duty form can be a valuable tool. Let's say for those employees who may try to extend their FMLA leave, even though they've been, cleared to return to work. But you want to tread these lightly. These scenarios can be tricky if you come across them. So again, don't be quick to terminate an employee. The specifics of the situation should be discussed to determine the best course of action. And so you should contact someone in HR and our Frank advice team so that we can kind of talk about the specifics and what has gone on with them, and then we'll be able to better guide you. So to recap a little bit, here are some reminders for you as an employer. Be sure that you do not forget to do these things during the FMLA process, since they are key requirements of covered employers. Um, remember to notify employees of their rights to FMLA. Point out the FMLA policy in the company handbook if you have one, or in the poster that you can provide them. Either you can email it to them, or it may be posted in your office if you have a location. And then, provide them notices that they're made aware of the potential need for any FMLA. Continue health benefits at the same level as before the start of FMLA leave. Again, any benefits, you want to continue just as if they were working. And then you want to reinstate the employees to the same or equivalent position at the conclusion of their FMLA leave. And you want to make sure that you keep records of all this stuff so that in the event that something happens, there's a claim or a suit that is brought, that you can kind of prove how you met all the requirements, and you would be able to do so by maintaining records. So Now that we talked about reminders, let's talk about some common mistakes that some employers make and that you want to avoid. Number one is retaliating against an employee who has taken leave. Remember, FMLA is a federal law that entitles qualified employees to take this job protected leave, and you want to ensure that you don't retaliate against them, whether advertently or inadvertently, and that you don't treat them differently for taking the leave. Another mistake is automatically terminating an employee who has exhausted their leave. So sometimes employers want to automatically terminate the employee when they've used, let's say they've used their 12 weeks and that's all they're entitled to. And at 12 weeks and one day they just go ahead, okay, then come back, they're done. But understand that that's not the best practice. And while employers often say, oh, well, the employee never contacted me. Well, that's not likely to be a good defense for you. Remember, there's communication is key with FMLA, and so you also share some of that responsibility. So if they don't contact you, then it's your responsibility to contact them and check on their status. Now, the main reason why you also want to do this is because once FMLA is exhausted, there may be other laws that kind of come into play that protect the employee. And one is the Americans with Disability Act, or the ADA as it's more commonly known. So let's say an employee whose FMLA leave has exhausted and informs you whatever treatment they're on is rendering them disabled for, let's say, an additional week, but that their doctor anticipates clearing them at the end of that week. Well, the ADA, or the Americans with Disability Act, may consider an additional week of time off as a reasonable accommodation. And so, again, I don't want to go off on a tangent because the ADA has a lot more information that goes with it. There has been a recent case where kind of close the gap a little bit on what reasonable accommodation is. But if you have questions about that, we can always contact us directly and we'll give you more on the ADA. The next mistake is counting FMLA related absences towards a no-fault attendance policies. An example of that is, let's say a company has attendance policies where any type of absence is recorded in their attendance records, regardless of the circumstances. And, sometimes an example I can think of this is a point system. So regardless of the fact, you have one absence, you get 1 point, you have one tardy, you get another point, and then at the end of all of these points, an employee may be subject to corrective action or demerit, or they don't get to go to the pizza party, whatever the reward is. So if you count these against the employee, then you shouldn't be, because you're kind of holding FMLA absence negatively against the employee. So remember not to hold it against the employees in any way when they were taking FMLA leave. And it's also important to know that if you're not an FMLA covered employer, to exclude FMLA language from your employee handbook. There have been cases where if you put it in a handbook and then an employee asks for it and you don't provide it, that you're maybe offering them benefits, and so it kind of gets murky, so you don't want to do that. Not allowing employees to take intermittent leave. So with FMLA, the allowable leave does not have to be taken continuously. So they can take it in, separate days or separate times. And let's say an employee needs to maybe take off half a day to go to the doctor to seek treatment. Well, they can do that. They don't have to just take 12 weeks all at once. So employers tend to not like this because it's a lot of work, and the responsibility is on them to keep track of the time that the employees are out, and it becomes cumbersome. But this is allowed under FMLA, and so you can't force an employee to take, either take all 12 weeks or nothing at all. You can't do that. When an employee is using intermittent leave, you would track hours, and so they would be eligible for up to 480 hours. So remember that this is allowable. Likewise, employers cannot require employees to work light duty as opposed to taking FMLA leave. So if the employee is asking for FMLA leave, allow them to take it. Another mistake is not designating the leave as FMLA. Remember, I mentioned earlier, this is not something that you can do retroactively without adversely impacting the employees. So when leave is not designated, it can put you as the employer in a situation where you may have to grant the employee additional time other than the 12 weeks because it wasn't designated. So you want to make sure that you designate the time. And then one of the most common mistakes that we kind of come across is not designated the time an employee is out of work when it's related to a workers' comp injury. So if an employee needs to be out because of an injury that happened on the job, they can be out due to the workers' comp injury, so it can run concurrently with FMLA. And so the employee can still go through the normal workers' comp process. And, if you also designate the time as FMLA leave, then that kind of, you've designated the time and it doesn't allow for them to have even more time when they come back. Employers should not assume that the employees are now a liability, as people like to call it, and start planning to change any terms of their employment. So we've already discussed how the leave is protected, and unless you get documentation from a medical provider stating that the employee has limitations, you cannot make assumptions. So I understand sometimes some jobs are safety sensitive, but remember, that's what you have the fitness for duty forms that you can rely on that. So follow whatever guidelines are on that form and let the medical provider tell you what restrictions or limitations an employee has. Some of the quick not to do's. Again, if you're not an FMLA covered employer, do not put it in your handbook. Sometimes employers think that it's easier. Oh, I'm going to grow, and so in the next 6 months, I'm going to have double of my staff. Well, until that happens, remember, you can always notify them of their rights later on. But in the meantime, don't put it in the handbook because otherwise you would have to offer it. And then not offering the benefit, only waiting for employees to request it. Remember, if it appears they have a qualifying reason, communicate it with the employee. And not training your managers and supervisors. Remember, they're your first line of defense. You want them to be aware and alert and know when to contact you and let you know, or someone in HR. So with FMLA, communication is key. And it is a shared responsibility. You can't just put the communication part on the employee and say, well, the employee didn't contact me. If they don't contact you, you contact them. And if they're not answering the phone, you send them a letter, but be sure that you go ahead and contact the employees. And so let's see if we have some time for questions. Yeah, we're doing good on time. So June?
Sure. Good afternoon, everyone. Thank you for attending, and thank you, Nanette, for that great information you gave us. Here are some of the questions that came in during the webinar. Can we move an employee to a different job when they come back from their leave?
That's a good question, especially sometimes, like I said earlier, you bring somebody in to help and then you kind of like the way they do the job better. But when an employee takes FMLA upon their return, um, again, the FMLA requires that you put the employee back to the same job or one that is nearly identical. So you want to, again, if the job is not the same exact position that the employee left, so what you want to look at is you're going to put them into a different job. You want to make sure that it offers the same shift, general work schedule, that it's in the same area. So not something that if they worked in one general area, then now you're sending them far away. You want to make sure that it kind of has the same duties or responsibilities or the same status in employment. It should be that the job requires the same skill level, effort, or responsibility and authority. And as far as the pay, it should be the same amount of pay. And you want to make sure that they're not affected as far as overtime or bonus opportunities, profit sharing, any type of income that they had the opportunity to earn before. You want to make sure that those are kind of the same. And the same goes for benefits. So whatever it is, whether it's health insurance and disability, sick leave, vacation, education benefits, all that stuff should remain the same. So if it's not the same exact job, it should be identical or very similar in all aspects. June?
Thank you, Nanette. Here's another question. Can we ask the employee to get a second medical opinion for their certification if we think there's something that's not right with the one they provide?
Okay, so to understand the question, if you think that the medical certification you received is, not exactly 100%, or you think that there's something funky going on, well, so there's a couple of things with this. And first, before I answer that question, let me just clarify some things. So let's say you receive a medical certification that's incomplete. You can let the employee know. You must do this in writing because, again, you want to make sure you document all this stuff so there isn't the perception of any retaliation. So you can let them know in writing that there's missing information, let them know what the information that's missing is, and then allow him or her reasonable opportunity to get information that's missing. And I believe you must allow them 7 calendar days to provide you with the missing information. Now, I've run across the instances where, employees don't really are not trusting the validity of the certification, or sometimes they just need, clarification because, sometimes medical providers are in a rush and they kind of fill out the forms, and so they're not really clear on what they're telling you. And so you can, as the employer, be able to contact the medical provider. Now, understand that they're not going to provide you with specific medical information. So if you're going to call them in hopes of that, you're probably not going to get that. But they'll be able to clarify, well, no, what we meant was not lifting more than 30 pounds or, something along those lines. And so also very important, the only person that should be contacting the medical provider is the person in your company who handles HR matters. So in other words, you don't want to have the employee's supervisor or manager be the one contacting the medical provider, because this is actually prohibited by the FMLA. So make sure it's the person that's in charge of HR matters. But to answer the question, yes, you may be able to request that the employee get a second opinion, but you will be responsible for the costs associated with the request. So depending on the situation, look at why it is that you want a second opinion, and maybe some of the other options or scenarios that I mentioned would suffice in getting you the information that you need.
Great, thank you. Next question. What do I do if an employee does not meet the requirements for FMLA, but is pregnant and needs to be out? Do I need to hold her job?
This is a really, really good question. Most employers assume that pregnancy, there's a maternity leave, and when there may be something in your state, but generally, remember, we're talking about FMLA on the federal level, like I mentioned at the beginning. So if there aren't any state laws in your state that require you to do otherwise, you do not have to hold the position, because remember, FMLA provides for job protected leave. And so if you're not an FMLA covered employer, or the employee is not eligible, then you do not need to hold the position. But what you want to make sure that you do is that you treat that employee, or you treat all employees with all illnesses or disabilities the same way. So what you would do is you would make sure that you treat, your pregnant employee the same way you would treat a male employee who maybe had a heart attack, so that you're providing them all the same benefits. So if you provide, the female with 2 weeks leave, that you're doing the same for your male employees. And so it looks, June, like we've are kind of running short of time. So all other questions that we have not answered, we will reach you by email, and we'll contact you so that we can give you your responses. Andrea?
Thank you, Nanette, and that is right. If you have any further questions or need assistance with anything, just please feel free to contact anyone here listed on this last slide, or just call the Frank Advice line directly, or frankadvice@frankcrum.com. And just thank you again for joining us. And in closing, at Frank Crum, we stand on our brand promise to inspire businesses like yours to be the best they can be. Have a wonderful day, everyone.